Hello, this is Katy Clemens, and you are watching Rule Synthesis. In this video, you will learn how to create a rule synthesis chart, improve your ability to pick a rule out of a source, and learn how to turn a rule synthesis chart into a rule statement for a brief or another argument for which you might need a rule statement. This is a rule synthesis chart. As you can see, we have our sources of law on the left. Some examples would be statutes, regulations, case law. And then across the top, we separate out our rule. We have an umbrella rule, and then the elements broken out from that umbrella rule. In this case, we have 3 elements. Of course, in other cases, you may have 2 elements, 4, 5. You may also have different numbers of sources of law. You can make this chart as large or as small as you need to. We're going to start with an easy one, the rule of ice cream that I completely made up. Let's start with a statute, a made-up statute, that says that ice cream is wet, cold, and delicious. There's a regulation that helps to bring out some of the details of the statute. The regulation says that for the purposes of ice cream, wetness is defined as leaving a liquid residue on anything it touches. Then we have some case law, Robbins versus Creamery, in which the court held, therefore, we hold that the substance that Robbins was selling was indeed cold enough to be considered ice cream, as it was under 32 degrees Fahrenheit. And one more case, Moo versus Jerry's, in which the court held, it would seem to us, based on the legislative and regulatory history, that the deliciousness of ice cream must be determined by the level of enjoyment the reasonable person would take in consuming it. If the reasonable eater would rate the ice cream a score of at least a 7 out of 10, then it can be considered delicious for the purposes of 38 U.S.C. 5555. So we have 4 sources here from which we're going to pull out the rules, both an umbrella rule and the various elements and the details that the regulation and cases give us on those elements, and put them into a chart. Here's our chart. So as you can see, I've listed the sources of law that we just read on the left side, and I've put the umbrella rule and the elements across the top and across from the various sources that explain those elements. So as you can see, the statute gives us a nice umbrella rule with 3 elements, and then the regulation in each case helps us by defining those elements. So then how do we take a chart like this and turn it into a rule statement? This is our rule statement, or a sample rule statement. There's more than one way to do this, of course. Pursuant to 38 U.S.C. 5555, ice cream must be wet, cold, and delicious. For these purposes, an item is wet if it leaves a liquid residue on anything it touches, cold if its temperature is below 32 degrees Fahrenheit, and delicious if a reasonable person would rate its taste at least a 7 out of 10. And then we cite all of our sources for these definitions. So hopefully you can see how we got from this, our sources, into our chart, where we made our rule plain and easier for us to understand by lifting it out of the sources and putting it into a chart so that we could see how the different rules apply to one another. And then how we got to the rule statement from there. There are various ways to mix the various elements together in your rule statement, but it's good to think about whatever makes sense and whatever you would need to know first and then next. Let's try a harder one. So now we're going to get into veterans' benefits, which is of course a bit trickier than the definition of ice cream, but we chose one with a rule and several elements so that we can show you how a rule synthesis chart can be done even in a more complex legal situation. Our client, Mr. Gerald Veteran, served in the Army from 1987 to 1992, including a deployment to Iraq from June to November of 1991. He states that he has been having regular pain in all of his joints ever since that deployment, but none of the doctors that he has seen over the years has been able to diagnose his condition, although they have confirmed that he does indeed experience significant joint pain. So here is our question. Is Mr. Veteran entitled to application of the, quote, Gulf War presumption to his claim? So we know that that's what we have to go figure out. What is the Gulf War presumption? And can Mr. Veteran get the benefit of that presumption? Here are some sources. Now, just so you know, this is not the beginning and end of the Gulf War presumption. This presumption can get very complicated and very detailed, but we took a large portion of it here so that we could create a rule statement that would help us with this hypothetical. First, we have a case called Gutierrez v. Principi, which is one of those cases that beautifully spells out some of the elements of the Persian Gulf War presumption. Allow me to read it to you. In order to be entitled to the presumption, and that is not part of the quote from the case, the quote begins here, a claimant must produce evidence that he or she is a Persian Gulf veteran who 1. Exhibits objective indications, 2. Of a chronic disability such as those listed in paragraph B of 38 CFR 3.317, 3. Which became manifest either during active military, naval, or air service in the Southwest Asia Theater of Operations during the Persian Gulf War, or to a degree of 10% or more not later than December 31st, 2021, and 4. Such symptomatology by history, physical examination, and laboratory tests cannot be attributed to any known clinical diagnosis. Then we have some other sources here that I'm going to read to you briefly. 38 U.S.C. 1117F says the term Persian Gulf veteran means a veteran who served on active duty in the armed forces in the Southwest Asia Theater of Operations during the Persian Gulf War. Regulation 38 CFR 3.2I says that the Persian Gulf War time period is from August 2, 1990 through date to be prescribed by presidential proclamation or law. And then we have several different paragraphs from the Regulation 38 CFR 3.317. A3 says, objective indications of chronic disability include both signs, in the medical sense of objective evidence perceptible to an examining physician, and other non-medical indicators that are capable of independent verification. Paragraph A4 says that disabilities that have existed for 6 months or more and disabilities that exhibit intermittent episodes of improvement and worsening over a 6-month period will be considered chronic. Paragraph B5 does include joint pain, and paragraph E2 says that the Southwest Asia Theater of Operations refers to Iraq and then goes on to list other countries and areas that are included. So these are our sources that we are working with, and we want to pull the rules and the rule sections and the elements out of these sources and put them in a chart. Let's see how we do that. Here is our Gulf War presumption rule synthesis chart. As you can see, I put all of our sources of law on the left, the Gutierrez case, the statute, and all the different paragraphs of the relevant regulations. I've spelled out the elements across the top. I did not repeat an umbrella rule here. Sometimes I find it helpful, sometimes I don't. You may feel the same. Here, it made more sense to me to just separate them out right away because the umbrella rule would really just be all of that smushed together, and that's not necessarily helpful to have in the chart. So the elements we have here, Persian Gulf veteran, objective indications, chronic disability listed in this paragraph, or such as those listed in this paragraph, started during the service or to a degree of 10% or more later. Obviously that time period has not ended yet. And element 5 can't be diagnosed. So let's see what the various rule elements that we have from the other sources where they fit under these elements. You can see that 1117F, 3.317E2, and 3.2I all apply to element 1. What is a Persian Gulf veteran? A Persian Gulf veteran had active duty in the Southwest Asia Theater of Operations, which includes Iraq, and they had active duty in that area during the Persian Gulf War, which is August 2nd, 1990 to the present. So that's helpful. Then we have element 2, objective indications. 3.317E2 is helpful with that. They're either signs or non-medical indicators, and it defines what those are. Element 3, a chronic disability listed in that paragraph, and we have a definition of chronic in 3.317A4. And in the list of disabilities listed under paragraph B, we do have joint pain, which helps us with our case for Mr. Veteran. Element 4 and element 5, we don't have any particular sources right now that make those more explicit. However, there are sources out there, and it can get very complicated, but we were just doing the main elements of this today for our purposes. So now let's see how we take this in this chart and turn it into a rule statement. Here's our rule statement. Persian Gulf War veterans are entitled to a special presumption of service connection if they suffer from certain chronic undiagnosable disabilities that began either during their Gulf War service or to a degree of at least 10% or more at any point since. A Persian Gulf War veteran must be able to show service in the Southwest Asia Theater of Operations, to include Iraq during the Persian Gulf War, which officially began on August 2, 1990 and continues to the present day. The veteran's disability must be one of a prescribed list, which includes joint pain, and it must be chronic, which means that it must have exhibited either constantly or intermittently for at least 6 months. Finally, the veteran must be able to show objective indications of the condition, which can be either objective signs perceptible to a medical examiner or other non-medical indicators capable of independent verification. As you can see, I skipped over reading the sources, but they're in there so that anybody who's reading my rule statement, a judge, opposing counsel, my client, knows where to go to find those definitions that I just pointed out to them. Hopefully you can see how this brought together our umbrella rule and then all of the different elements and the explanations of the elements to make a rule statement that hopefully reads fairly clearly so that everybody can follow what's going on and sets up how we can apply the facts to this case. So how can we apply the facts to this case? What about our client, Mr. Veteran, here? I have the facts up here again as a reminder. Is he entitled to application of the Gulf War presumption? Yes, he is. He served in the required area because he was in Iraq, during the required time period because 1991 is since August 2nd, 1990. His condition is joint pain, which is on the list, and he says that it began while he was still serving in the Gulf. Remember, it needs to have begun either during the service or at any point since, but if it's at any point since, it has to be at least 10% disabling. He says that he has had pain since 1991. Obviously, 1991 to the present is much more than 6 months, so it's definitely chronic. His doctors have confirmed that he suffers from pain, and so that constitutes a sign of the disability, a medical objective evidence that a medical doctor was able to confirm. And finally, his doctors have not been able to diagnose his condition, so it is what is commonly called an undiagnosed illness for purposes of the Gulf War presumption. So I hope that that helps you look at using a rule synthesis chart to help develop your rule statement whenever you're looking, particularly in an area where you have an umbrella rule, you have several elements, you have a bunch of different sources looking at all different parts of the rule. Hopefully this will help you separate it out, see it a little more clearly, and then put it all together in a way that is clear and easily applied to your facts. Thanks and good luck.